After studying this module, you shall be able to know about the Sebi guidelines on appointment of merchant banker, learn about the Sebi guideline on underwriter, understand the Sebi guideline on brokers, know about the Sebi guideline on register and bankers, learn about allotment of share. Introduction. Financial markets have an important relationship with economic development. Many intermediaries are involved in connection with the public issue. Following are the intermediaries who have to be registered with Sebi and must have valid certificate from Sebi to act as an intermediaries. First is merchant bankers. They play the most vital role amongst all intermediaries. They assist the company right from preparing prospectus to the listing of securities at the stock exchanges. Merchant bankers have to satisfy themselves about the correctness and propriety of all the information provided in the prospectus. It is mandatory for them to carry due diligence for all the information provided in the prospectus, and they must issue a certificate to this effect to Sebi. A company may appoint more than one merchant banker provided the merchant bankers are properly structured. Second is underwriters. Underwriters are those intermediaries who underwrite the securities offered to the public. In case there is undersubscription which occurs when the company does not receive good response from public and amount received from is less than the size, underwriters subscribe to the unsubscribed amount so that the issue is successful. Third is registrar and transfer agent. They process all applications received from the public and prepare the basis for allotment. The dispatch of share certificates, refund orders are handled by them. Fourth is bankers to the issue. Are banks which accept application from the public on behalf of the company are known as bankers to the issue. These applications are then forwarded to registrar and share transfer agent for further processing. Fifth is stock brokers and sub-brokers. Stock brokers and sub-brokers are those intermediaries who through their contacts sources invite the public for subscribing shares for which they get commission. Let us now discuss the Sebi guidelines on appointment of merchant bankers. Merchant banking is the direct, negotiated investment of private money into privately or publicly held companies by financial institutions or professional investors. The investors make private placements of equity and in return receive private stock that is not registered with financial regulators for trading on an exchange. In a way, they are becoming financial partners of the companies. Merchant banking has been statutorily brought within the framework of the Securities and Exchange Board of India. A merchant banker will require authorization by Sebi to carry out the business. Next is types of merchant bankers. Sebi has classified the merchant bankers into 4 categories based on the nature and range of the activities and the responsibilities. Category first. It consists of merchant bankers who carry on the business of issue management, which consists of preparation of issue management, which consists of preparation of prospectus, determining the financial structure, tie-up of the financiers and final allotment, refund of subscription, and to act in the capacity of managers, advisors or consultants to an issue. Portfolio manager and underwriter. Minimum net worth required is rupees 1 crore. Category second. It consists of those authorized to act in the capacity of co-manager, advisor, consultant, underwriter to an issue. The minimum net worth required is rupees 50 lakhs. Category third, it consists of those authorized to act as underwriter, advisor or consultant to an issue. The minimum net worth required is rupees 20 lakhs. Category fourth, it consists of merchant banker who acts as advisor or consultant to an issue. One thing that needs to be kept in mind is that there is no minimum net worth required. Next is requirements of documents. First, every merchant banker should maintain copies of balance sheet, profit and loss account, statement of financial position. Second, half yearly unaudited result should be submitted to Sebi. Third, Sebi has been vested with the power to suspend or cancel the authorization in case of violation of the guidelines. Fourth, every merchant banker shall appoint a compliance officer to monitor compliance of the Act. Fifth, Sebi has the right to send inspecting authority to inspect books of accounts, records, etc. of merchant bankers. Sixth, inspections will be conducted by Sebi to ensure that provisions of the regulations are properly complied. Seventh, an initial authorization fee, an annual fee and renewal fee may be collected by Sebi. Eighth, a lead manager holding a certificate under Category 1 shall accept a minimum underwriting obligation of 5% of size of issue or rupees 25 lakhs, whichever is less. We shall now discuss the Sebi guidelines on underwriter. Underwriting is the nature of an insurance against the adverse situation in the timing of the public issue. It can be defined as bearing the risk of not being able to sell a security at the established price by virtue of purchasing the security for resale to the public, also known as firm commitment underwriting. The person who assures is called as underwriter and the consideration for the assurance is known as underwriting commission. The underwriters give guarantee for the public subscription and in turn they receive the commission. In public issues, after the merchant bankers, the next position goes to the underwriters, where they play a very major role. The Sebi has defined the underwriting as an agreement with or without conditions to subscribe to the securities of a body corporate where the existing shareholders of such body corporate or the public do not subscribe to securities offered to them. The underwriter has been defined as a person who engage in the business of underwriting of an issue of securities of a body corporate. The underwriting is mandatory for the public issue. The stock exchange regulations clearly specify that no stockbroker is allowed to underwrite more than 5% of the public issue and the concerned stock exchange should approve the appointment of broker underwriters. Usually, the bankers can underwrite up to 10% of the public issue. The underwriting commission cannot be paid on the amounts contributed by promoters, directors, employees and business associates. It is an important element of the primary market. It is appointed by the issuing company in consultation with the merchant bankers. The name of the underwriter and his obligations should be disclosed in the prospectus. There are a number of financial institutions, commercial banks, insurance companies as well as a number of private companies which provide underwriting. An underwriter issue is the safe way of marketing securities and the investors are influenced by the prestige of the underwriters. The issuing companies may appoint one or more of the following parties: A. Financial institutions, B. Brokers, C. Bankers, D. Investment companies and E. Trust. According to Sebi Underwriters Rules and Regulations 1993 Section 30, the prospective person should apply for the grant of the certificate in a particular format, Form A as per regulation. The board takes into account all the matters that are relevant to underwriting and particularly regarding the below facilities before granting the certificate. First, the applicant has the necessary infrastructure. Second, the applicant should have the experience, otherwise he should appoint 2 experienced members. Third, the underwriter should satisfy the capital adequacy requirement of net worth of rupees 20 lakhs. Fourth, the purpose of net worth means the applicant might be a proprietary concern or a firm or an association of persons or anybody of individuals. The value of capital plus free reserves of business. Fifth, in the case of a body corporate, the value of the paid up capital plus free reserves should be disclosed in the books of accounts of the applicant. Sixth, if the Sebi believes that the applicant is eligible, then it sends intimation to the applicant that he/she is eligible for the grant of the certificate, and thus it grants the certificate in Form B after the payment of the prescribed fee. Seventh, the underwriting agreement should be filed with the stock exchanges. Eighth, the registration number of the underwriter is to be quoted in all correspondence with the Sebi, government authorities and clients. Ninth, the Sebi may issue warning letters or penalty advances by which the underwriters would be forewarned in respect of their omissions. 10th, in order to standardize the legal relationship between the issuing company and the underwriters, the Sebi has formulated the model underwriting agreement. 11th, the total underwriting obligations under all the agreements should not exceed 20 times the net worth of the underwriter. Sebi has given some guideline on brokers. We shall now discuss those guidelines. For working with stock exchanges, stockbrokers registration is mandatory. A stockbroker applies in the prescribed format for grant of a certificate through the stock exchange or stock exchanges as the case may be, of which he is admitted as a member. The stock exchange forwards the application form to Sebi as early as possible, but not later than 30 days from the date of its receipt. Sebi takes into account for considering the grant of a certificate all matters relating to buying, selling or dealing in securities. Conditions to be satisfied by brokers are: first, eligibility to be admitted as a member of a stock exchange. Second, the presence of necessary infrastructure like adequate office space, equipment and manpower to effectively discharge his activities. Third, brokers' past experience in the business of buying, selling or dealing in securities. Fourth, ensure that the broker is not subjected to disciplinary proceedings under the rules, regulations and bylaws of a stock exchange with respect to his business as a stockbroker involving either himself or any of his partners, directors or employees. And fifth, broker should be a fit person physically and mentally. Sebi, on being satisfied that the stockbroker is eligible, grants a certificate to the stockbroker and sends intimation to that effect to the stock exchange or stock exchanges as the case may be. Where an application for grant of certificate does not fulfill the requirements, Sebi may reject the application after giving a reasonable opportunity of being heard. Moving forward, let us discuss the Sebi guideline on registrar and banker. First, the banker to an issue who has been granted or deemed to have been granted a certificate of initial registration under regulation may 3 months before the expiry of the period of certificate of initial registration make an application for grant of a certificate of permanent registration in Form A. Second, the banker to an issue who has already been granted a certificate of registration by the board and has completed a period of 5 years on the date of commencement of the Securities and Exchange Board of India Bankers to an Issue Amendment Regulations 2011 may 3 months before the expiry of validity of certificate of registration or before make an application for grant of a certificate of permanent registration in Form A. Third, an application under Sub-Regulation 1 or Sub-Regulation 2 shall be accompanied by non-refundable application fee as specified in Schedule 2 of these regulations. Fourth, the application for grant of a certificate of permanent registration shall be accompanied by details of the changes that have taken place in the information that was submitted to the board while seeking initial registration or renewal as the case may be, and a declaration stating that no changes other than those as mentioned in such details have taken place. Fifth, the application for permanent registration made under Sub-Regulation 1 or 2 shall be dealt with in the same manner as if it were a fresh application for grant of a certificate of initial registration. Sixth, the board, on being satisfied that the applicant is eligible, shall grant a certificate of permanent registration in Form B and shall sign intimation to the applicant. Seventh, the grant of a certificate of permanent registration shall be subject to payment of fees specified in Schedule 2 of these regulations. Let us now discuss the method of allotment of share. First, Section 39 of the Act prohibits allotment of securities where the minimum amount as stated in the prospectus has not been subscribed. The section further provides that for refund within a given time frame. Second, it provides that all of the minimum amount must be received within a period of 30 days from the date of issue of the prospectus or such other period as may be specified by the Securities and Exchange Board. If minimum subscription remains unsubscribed, it shall be returned within such time and manner as may be prescribed. Third, the rules provide that where the stated minimum amount has not been subscribed and the sum payable on application is not received within the period specified therein, then the application money shall be repaid within a period of 15 days from the closure of the issue, and if any such money is not so repaid within such period, the directors of the company who are officers in default shall jointly and severally be liable to repay that money with interest at the rate of 15% per annum. The application money to be refunded shall be credited only to the bank account from which the subscription was remitted. Fourth, the section provides that the minimum amount of every security shall not be less than 5% of the nominal amount of the security or such other percentage or amount as may be specified by the Securities and Exchange Board by making regulations in this behalf. Fifth, a company having a share capital makes any allotment of securities shall file with the Registrar a return of allotment in such prescribed manner. The rules provide that whenever a company having a share capital makes any allotment of its securities, the company shall within 30 days thereafter file with the Registrar a return of allotment in Form PAS 3 along with the fee as specified in the company's registration offices and fees rules 2014. Sixth, the rules further provide for the attachments to Form PAS 3, that is return of allotment as under: A list of allottees stating their names, address, occupation, if any, and number of securities allotted to each of the allottees. B. The list shall be certified by the signatory of the Form PAS 3 being complete and correct as per the records of the company. C. In the case of securities not being bonus shares allotted as fully or partly paid up for consideration other than cash, there shall be attached to the form PAS3 a copy of the contract being duly stamped pursuant to which the securities have been allotted together with any contract of sale if relating to a property or an asset or a contract for services or other consideration. D. A report of a registered valuer in respect of valuation of the consideration other than cash shall also be attached along with the copy of the contract. E. In the case of issue of bonus shares, a copy of the resolution authorizing the issue of such shares shall be attached to the form PAS3. F. All money received on application from the public for subscription to the securities shall be kept in separate bank account in a scheduled bank. Such money can be utilized only for the following two purposes. A. For adjustment against allotment of securities where the securities have been permitted listing, or B. For the repayment of monies within this time specified by the Securities and Exchange Board received from applicants in pursuance of the prospectus where the company is for any other reason unable to allot securities. Next is the procedure of security allotment. First, in case an issuer company makes an issue of 100% of the net offer to public through 100% book building process. A. Not less than 35% of the net offer to the public shall be available for allocation to retail individual investors. B. Not less than 463, that is 15% of the net offer to the public shall be available for allocation to non-institutional investors, that is investors other than retail individual investors and qualified institutional buyers. C. Not more than 50% of the net offer to the public shall be available for allocation to qualified institutional buyers. Second, in case an issuer company makes an issue of 75% of the net offer to public through book building process and 25% at the price determined through book building. A. In the book built portion, not less than 25% of the net offer to the public shall be available for allocation to non-qualified institutional buyers, and not more than 50% of the net offer to the public shall be available for allocation to qualified institutional buyers. B. The balance 25% of the net offer to the public offered at a price determined through book building shall be available only to retail individual investors who have either not participated or have not received any allocation in the book built portion. Third, allotment to retail individual investors, non-institutional investors and qualified institutional buyers shall be made proportionately as illustrated in Schedule 18th. Fourth, the broker shall refund the margin money collected earlier within 3 days of receipt of basis of allocation to the applicants who did not receive allocation. Fifth, allotment shall be made not later than 15 days from the closure of the issue, failing which interest at the rate of 15% shall be paid to the investors. Sixth, on payment and receipt of the sum payable on application for the amount towards minimum subscription, the company shall allot the shares to the applicants as per these guidelines. Seventh, in case the issuer company has made an issue of 75% to the net offer to public through book building process and 25% at the price determined through book building. A. The offer of 25% of the net offer to the public made at a price determined through book building shall open within 15 days from the date of closure of bidding. B. The offer for subscription to the public shall remain open for a period of at least 3 working days after completing all the requirements of advertisement, and dispatch of issue material to all the stock exchanges. C. During the time when the offer is open, the investors who have received an intimation of entitlement of securities under subclause 18 of clause 11.31 shall submit the application forms along with the application monies. D. The other retail individual investors who had not participated in the bidding process or have not received intimation of entitlement of securities under subclause 18 of clause 11.31 may also make an application. I repeat, clause 11.3.1 may also make an application. Let us summarize our discussion so far. Merchant banking is the direct negotiated investment of private money into privately or publicly held companies by financial institutions or professional investors. Underwriting is the nature of an insurance against the adverse situation in the timing of the public issue. It can be defined as bearing the risk of not being able to sell a security. A stockbroker applies in the prescribed format for grant of a certificate through the stock exchange or stock exchanges, as the case may be, of which he is admitted as a member. The banker to an issue who has been granted or deemed to have been granted a certificate of initial registration under regulation may 3 months before the expiry of the period of certificate of initial registration make an application for grant of a certificate of permanent registration in Form A. Section 39 of the Act prohibits allotment of securities where the minimum amount as stated in the prospectus has not been subscribed. The section further provides that for refund within a given time frame. It provides that all of the minimum amount must be received within a period of 30 days from the date of issue of the prospectus or such other period as may be specified by the Securities and Exchange Board. If minimum subscription remains unsubscribed, it shall be returned within such time and manner as they may be prescribed. Thank you.